afternoon, everyone. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. And in today's live Facebook presentation, I would like to provide you with written updates regarding public charge rule and what's happening with public charge rule. You're probably aware, if you're an immigrant in the United States or you're seeking to sponsor your family member in the United States or file for adjustment of status, you are aware that currently this year, let's say starting from February 24th, 2020, a person who was seeking to file for adjustment of status had to attach a declaration of self-sufficiency. Hi everyone. Hi Maria. And what happened was that, of course, when the rule was drafted, the new public rule was drafted, nobody predicted that there will be pandemic, right? And we're all going to be locked up in our houses, we will lose jobs, we'll not be able to basically have the same life as we used to. Nevertheless, the rule was in effect starting February 24th, 2020, and USCIS did state that they will not consider let's say certain medical services that people are receiving in connection with COVID. They will not take those services into consideration when they're assessing if a person is likely to become a public charge. But many human rights organizations, immigration organizations felt that it was not enough, that really during the pandemic, people should not be worrying about the public charge. So there was a lawsuit filed. The lawsuit was filed prior. The lawsuit was filed back in when the rule was just set to be implemented 2000, I believe 2018 or 19. And there was a preliminary injunction, meaning that the court, federal court in New York, first ruled, and it was a first ruling, that the public charge rule should be stopped, and it was stopped for a while until the highest court stated that, wait a second, the rule should go on. And while the lawsuit is happening, the rule should be allowed to be implemented. And that's where we were on February 24th, 2020. Okay? All right. But then, as I stated, the same plaintiffs in the lawsuits decided to ask the court again to stop the rule. This time, they stated that, listen, the situation changed dramatically, where in pandemic, it's unfair that people are scared to ask for medical attention because of the fear to become public charge. They want to use unemployment benefits, and even though unemployment benefits are not public charge benefits, people still reluctant to apply for various available forms of help during pandemic. And the court agreed, Southern District Court agreed. On July 29th, the court issued another stay of the public charge rule. And I had a video about that. It was a nationwide injunction, meaning that that rule that the court in Southern District made was good for the entire country. In fact, USCIS issued a new guidelines as to what they're going to do with public charge after the rule, after July 29th. It's still up on their website, saying that starting from July 29th, 2020, people who would like to file for adjustment of status do not have to submit Form I-944. Any information that they submitted before, including Form I-944, if they're up for consideration now, will not be taken into consideration, and it will continue as such for as long as Southern District's court decision is in effect. But what happened later was that the government appealed the ruling by the Southern District Court, and just recently, a higher court, a Second Circuit Court, stated that we agree that at the time of the pandemic, people should not be subject to public charge. But that rule, that stop of the public charge rule, should be good for 3 states only. Those states that are covered within our jurisdiction, which are Vermont, Connecticut, and New York. So the court limited the stay to those 3 states only, meaning that if you're somebody who's filing your case from those 3 states, if you reside in those 3 states, then you're not subject to the public charge rule right now. If you live next door, New Jersey, you are. So what the court's logic is that if New Jersey does not like what's happening, New Jersey should file their own lawsuit and challenge the rule in court. So that's where we're staying right now. I'm trying to explain it as simple as possible. Basically that for those of you who are in Vermont, Connecticut, New Jersey, New York, you're not subject to public charge rule. If you applied for free health insurance during these times, if you used SNAP benefits, that right now it's not being taken into consideration. You can file your adjustment of status right now without the form I-944. You don't have to attach any of those attachments that they ask for the form I-944. And if your case is pending right now, the government, and you're called for the interview, the government should not be asking you any questions regarding public charge and should not be taken into consideration any benefits that you could have received, any benefits that could have been considered public charge benefits, but only if you are in Vermont, Connecticut, New York. If you're in New Jersey, that's a different story. So it's kind of complicated, and that's where we're standing right now. Another important point about the public charge that I wanted to make, it's just because I keep getting those questions, and I think it's important, is that when the rule was changed, starting February 24, 2020, the government stated that they will be taking into consideration new benefits that now are falling under public charge rule only if they were received starting from February 24th onward. Okay? So, under my reading of their rule and their explanation, if a person was receiving benefits in 2018, for example, somebody used Medicaid, okay, for a year, and now they're filing for adjustment of status and they live in New Jersey, where you are subject to public charge rule, okay? Those benefits should not be taken into consideration. Why? Because according to the USCIS practice manual, the benefits that will be taken into consideration are only those that were applied for, received, used on or after February 24th, 2020. All right, so that's an important point. You can verify it on USCIS website if you don't believe me. All right, so that's very important. One more thing. When the new public charge rule came into effect, what happened is that they added certain benefits under the umbrella of those benefits that will cause determination of a person likely to become a public charge. But there was a rule in effect from 1999. It's always been the case that some benefits that you're using will cause you to become a public charge in immigration eyes. So if you've been using those benefits, regardless of February 24th, 2020, you still may be found to be public charge, even though you used those benefits before, benefits that were problems, so-called, under the old law. All right, so that's where we stand right now. So if you live in Vermont, Connecticut, New York, all you need to do when you're filing for the adjustment of status, you just need to submit your forms, I-45, petition underlying your basis for I-45 on approval notice, work permit documents, Form I-765, if you'd like to get permission to travel, I-131, but you don't need to file Form I-944, okay? It may change, It may change just because we see these changes practically every day. USCIS website still mentions only July 29th decision by the Southern District Court, and I didn't see any new announcement from them as to what to do with the Second Circuit Court's decision that limited the Southern District Court's decision validity for the not for the nation. But I guess what you need to do if you're filing for adjustment of status now is that on the date of the filing of submission of your package, you need to look at the website and take a screenshot, okay, to make sure that you do the right thing and you're actually following the USCIS most recent instructions. Because as I stated, now they're changing very, very rapidly. And now, guys, if you have any questions, I will be happy to answer some of those questions. Hello again. Thank you for joining me today. And let me see if you have any questions. If you go to interview in December and you don't hear from USCIS from that time till now, what should I do? Oh, I guess it depends on which interview you went to. If you felt that there were some issues uncovered during the interview, if you were questioned about potential inconsistencies. December, we have about 8 months now. I would say you should follow up with the officers. Of course, you have to understand that USCIS had some serious delays in their work. They're just restarting, okay? They're just restarting to interview people and so on. So I would say follow up with the place where you had the interview. If it was asylum interview, with asylum office. If it was a USCIS field office, with them. My I-130 was approved in 2017. Now I see that sent it to Department of State for review. What does it mean? Well, it means that perhaps they would like to revoke it, all right? Usually that's what it means, that they're trying to see if everything was done correctly and all the documents were real. So I would say that follow up with your attorney, okay? Usually when it happens, if Department of State determines that something is wrong, they're going to send you a notice, or your petitioner a notice, saying as to what they want to do with the approved petition. Right? So for the list of benefits that may be public charge, they're available online. It's very easy to find. You know, somebody asked if kids meals, the coupons that you receive for the formula, if they can be a problem. From the top of my head, I would not be able to answer that question, but here is a rule of thumb. If the beneficiary is a child who is a U.S. citizen, benefits received by the U.S. citizen obviously shouldn't be taken into consideration, correct? The problem is that maybe that the household to qualify for those benefits should show some sort of will show some income, right, below certain poverty guidelines, and that's why a person would qualify for those benefits. Then you're looking at the household as a whole, and of course, if you're questioned about your household's income and it's insufficient, then that may be a problem for the adjustment. All right. So that's where we stand right now with the forms. Now, also people asking me about when the USCIS offices are going to be reopened. Well, some of them are reopened already. For example, in New York, the offices are reopened. It's just that they have to pace themselves to schedule interviews because they cannot accommodate everybody at the same time because of the social distancing rules. And understandably, they work probably with less staff, right? Because if before you could have many people in the same place. Now you obviously can have just a limited amount of people. So basically what happens is that you have to be patient, all right? I just received updates a day ago about naturalization interviews, that the goal of the USCIS in New York is to reschedule everybody within the next 90 days. Those people who were supposed to get their interviews and they were canceled. So if you haven't been rescheduled within the next 90 days, you should expect a new hearing notice, okay? And as always, you can read more about immigration, various issues, waivers, public charge, what to do in different situations on our website, www.shautsova.com. Thank you very much for joining me today, and I hope you're going to have a great day.